Hi guys, I'm Annie Banerjee and I have been practicing business immigration law for about 20 plus years now in Houston, Texas, and I am making this video because, as many of you know, that from October 1, 2020, the filing dates for retrogressed countries in employment category system, that's India and China, but especially India, has advanced to a lot of degree and to a whole lot of time, and not so surprisingly, because this has happened in China before, and not so surprisingly, the EB-3 category has moved faster than the EB-2 category. So this video is going to deal with what to do if you want to downgrade your EB-2 category into the EB-3 category and file for adjustment of status, because that date is 2015, whereas EB-2 category date is 2011. So we are now going to, before I start, I want to give you a disclaimer. Everything I say has been done and approved by CIS in the past. Of course, I cannot read the future and I cannot tell you what CIS will do in the future, which is like even tomorrow, but I can tell you that probably it will be all right, and why that it would be so. Ultimately, if you want to have this process done, know that it's not 100%. Nothing in life is 100%. And I will also give you the worst case scenarios of what would happen. Now, as you know, the employment categories are set on EB-2, EB-3, and of course EB-1. Now EB-2 is the category for either people possessing or the job possessing at least the master's degree or a bachelor's degree plus 5 years of progressive experience. Now say you have an EB-2 and you've seen that the numbers for EB-3, which really is a category for only bachelor's degree holder, or even a lot of times associate degree plus some experience. So a lot of times this is obviously a lower requirement than an EB-2 job, and so you would need to downgrade your I-140 to file the I-485 on an EB-3 category rather than an EB-2 category. Now let's get the main things as to main answers. Can you file an I-140 amendment and to amend it to EB-3 category and simultaneously file the I-485? No, you cannot, because I-485 is based on the I-140. If the it kind of rests on the I-140 under the I-140. So if you want to do the downgrading, what do? Now here is what I would do, and I've done this in the past several times with no problems for Chinese national and even for Indian national at some point previously, and we've never had a problem. So what we would do is file the I-140. No, you do not have to file perm. I know a lot of lawyers are saying you have to file the perm, but no, you do not have to file the perm. As far as we know, Labor Department has never asked for that. This has nothing to do with the Labor Department. The 485 adjustment of status has to do with CIS. So we do not need to file another perm. So what do? We usually will file the I-140 as an amendment from EB-2 to EB-3. Now, and that would take 15 days because we are going to do it in premium. Meanwhile, we will get the I-485 ready, and as soon as that I-140 is approved, we just start and file the 485. Now, this I-140 has to be filed under premium. There is no choice in that. You do have to file in the premium. Usually, what does the I-140 adjudicate? The I-140 adjudicates that the employer has the ability to pay the individual, and the individual has the qualifications to do the job. Now, the CIS usually will approve them very quickly because, let's face it, the EB-2 job was obviously a higher salary, and the employer did show the ability to pay, although note that the ability to pay would be from the date of filing the I-140. So the employer would have to show that they did and they do have the ability to pay the EB-3 wages right now, and the second thing that I-140 adjudicates is whether the individual has the qualifications. Now, if you have an EB-2 approval anyways, you did have the qualification of an EB-2, so that's a pretty easy one. If you had the qualifications for EB-2, you would have the qualifications for EB-3. But the employer's payment, the employer's ability to pay would have to be shown, although note that EB-3 would have a lower prevailing wage, but we still need documents from the employer. Now, if you no longer work for the same employer, but you work in the same and similar job, you can port the new employer, but the new employer has to show that they do have the ability to pay for this job. So in other words, this porting from EB-2 to EB-3 cannot be done without the help of the employer, and that's something you need to establish before you want to file this or go ahead with the filing. Now, as I said, once the EB-3 application is approved by the CIS, then the CIS will go ahead and then we can go ahead, take that approval, make a copy, and send in the adjustment of status application. Now, in the past, it has always been quite easy to downgrade I-140 because, as I said, like if somebody meets the qualification of I-140 EB-2, then they would automatically meet the qualification of EB-3. But again, so usually when we did this in the past, we never had an RFE or anything. We just filed it and we got the approval, sometimes within a week, and then we could file the I-485. Now, again, of course, no guarantee, although those are the only two things that CIS has adjudication over, which is number one, that you do have the employee does have the qualification, which is a no-brainer, and the employer has the ability to pay. So now, in the past, Department of Labor had stayed out of this, and they have not said anything. Now, will they come back and say something? I don't know. I don't think so, because Department of Labor is being okay now, especially for specialty occupations. So I doubt they would do so. Now, what are the pros? The pros, of course, is that once the I-140 gets approved, you, your spouse, and everybody can just file that petition, and you will be done, and file the 485, and you're done. Well, you're done in the sense that you will get the visa fast. Now, what are the cons? The cons are because let's look at why EB-3 is proceeding at a much faster pace than EB-2. Now, EB-2 used to proceed much faster, and that was because there were not enough people who qualified under EB-2. But EB-3, a lot of EB-3 people, as you know, they have the bachelor's degree. Maybe in the past they did not have the required experience, so they would change employers. They would file EB-2 and they would upgrade to EB-2. Newer people coming in would also want to file in EB-2 because they thought EB-3 would take forever. And thus what happened is that EB-2 became oversubscribed. So there are more people from the Indian origin on EB-2 than there are on EB-3. And that is why EB-3 has progressed faster than the EB-2. Now, what if it's reversed? What if everybody now downgrades to EB-3 and file, and EB-3 becomes oversubscribed? I still hold that the original I-140 is merely amended. It has not been abandoned. So if we want to, the usual process for upgrading from EB-3 to EB-2 had been to file the perm, but in this case, you already have an EB-2 approved, and I would say we would just file with that EB-2. If EB-2 proceeds faster, you still retain the EB-2 category, and at the worst case scenario, CIS might ask you to just amend it again to the EB-2 category. But I don't really see a major hurdle in downgrading to EB-3 and then, if necessary, upgrading back again to EB-2. Now, of course, again, disclaimer, this is the Trump administration. So anyways, the way would absolutely be that you file the I-140 in premium, get an approval, and then you can file your EB-3 adjustment of status. And that is if your EB-2 application is anywhere between 2011 and 2015, the dates, those dates, and this will give you the chance of filing for an EB-2 category. EB-3 category, and filing your adjustment of status. What is the worst case scenario? Say we file the EB-3 and CIS does something or the other, takes away the ability to file for everyone, which has happened in the past. In 2006, we started filing on October 1. On October 2nd or 3rd day, CIS came back and said nobody can file. So of course there was a big uproar. So on the 15th or so, CIS again said that they would everybody can file. So that was a huge fiasco that happened in 2006. Not to say that it cannot happen right now, but in any case, even if CIS takes away the right to file right now, what will really you will lose would be the money that is spent to downgrade, because as I said, we would probably in that case just withdraw the application and keep our EB-2, or change it to 3 and keep it. So that's the basic money that you will lose. And yes, we would have to file this in premium processing. If CIS suddenly closes premium processing for I-140, then this will probably not be an option. You can still try, but we don't know how long these categories, this filing deadline will be available. My guess is that because a whole lot of people will apply, that the visa numbers are going to retrogress again in November. Now I'll be very happy if I'm wrong, but I think it will retrogress in November. So whether to do this or not, now that you know what the law is and the basis of the law is, it would be your choice. Would I do it if I had a similar situation? Yes, but again, this is your choice, because at the worst case scenario, you'll lose some money. At the best case scenario, you can file your adjustment of status. That way you're not tied to a single employer, and it just opens up a lot of possibilities, including, of course, the best possibility of all is that you will get your green card faster. Thank you. If you like this video, if you subscribe, this will get me to doing more videos like this. Thank you so much. Bye.